Good morning, everyone. My name is Joanna Rourke, and I am of counsel in the financial regulation team here at Mason Hayes Kern. And it is my pleasure to welcome you to today's webinar, Consumer Protection in Financial Services. Are you ready for change? We're at a pivotal moment for consumer protection in Ireland. The central bank's mandate has evolved significantly over the last 20 years. And as the audience will all be aware, there's a sharpened focus on the public interest and the protection of consumers. Many of the audience will be accustomed to dealing with the existing Consumer Protection Code. It was first introduced in 2006. And at that time, it was very much a principles-based code. Over time, and especially following the tracker mortgage examination, we've seen the code grown increasingly detailed and prescriptive. The revised 2025 CPC package is going to come into effect in March next year. It represents a landmark change for the industry, not least in the fact that it's documented in well over 300 pages, not including guidance. And it does reflect a global trend across jurisdictions towards stronger consumer protection standards. So in today's session, our aim is really to explore the practical challenges that firms will face in implementing the new code. And our experienced panelists are going to provide some advice in that respect, which hopefully will be very useful. So let me introduce our panel. Firstly, we have Liam Flynn, who is co-head of financial regulation at Mason Hayes Kern. Liam has extensive experience advising financial institutions on regulatory compliance and strategic implementation. We then have Rowena Fitzgerald, who is also co-head of financial regulation at Mason Hayes Kern. Rowena is an experienced advisor on consumer protection and regulatory risk management. We also have our colleague Dermot McGeer, who is a partner in the commercial team in MHC. And Dermot is very experienced in all areas of digital and technology challenges that firms face at the moment. And he's going to discuss the new code from that angle. And finally, we also are delighted to have Ben Hilary. Ben Hilary is a senior lawyer at Norton Fulbright in London. And Ben is going to share some valuable perspectives of the UK consumer duty and how firms in the UK have addressed those challenges. So with this great range of experts, I'm confident that today's discussion will be useful and practical for the audience. Maybe just to cover some housekeeping points. You will see there's a webinar poll there. We'd be really grateful if everyone could complete that poll. And at the end of the webinar, hopefully we'll have results for you and it will provide us with some insight on what the audience is thinking. There's also a Q&A box at the bottom of your screen to submit questions. Please do submit questions because our aim is to get to questions at the end and we want this webinar to be as engaging and useful for people as possible. So send those questions in as they occur to you. So I'll just get started because I'm sure there'll be lots to cover today. And Rowena, if I turn to you first, I mean, just from a very basic perspective, compared to the 2012 CPC, the 2025 is really an extensive set of documentation. So like, where should a reader really start, or how do they best navigate the new package?
Yeah, thanks, Joanne. And look, you're absolutely right. The 2025 Consumer Protection Package is significantly more complex and extensive than, say, the 2012 Code. I think it reflects how much the regulatory landscape, consumer expectations and financial services themselves have evolved over the last decade. Like you mentioned, we've moved from a more, say, reader-friendly single code to having hard law now with two statutory instruments, so two sets of regulations. We have the standards for business regulations and the consumer protection regulations. And then we've three pieces of guidance on top so far. So we have guidance relating to the conduct standard of securing customers' interests. We have guidance around protecting consumers in vulnerable circumstances. And then we've general code guidance as well. And together, like you say, they amount to hundreds of pages of regulation and guidance for firms to grapple with and comply with. So in terms of navigating the new rules, there's a couple of approaches. So the Central Bank has tried to make getting around the regulations as easy as possible, and they've set up a navigation tool on their website. And they've also published a tracker tool to track the carryover of the old CPC provisions to the new regulations. And that can be helpful for starting a firm's gap analysis to map out where you might need to get to under the new CPC framework. I think if you're tight for time, not everything in the new code is new or has, say, the same immediate impact for firms. I think firms should probably first focus on things like new or expanded standards. So, for example, the securing customers' interest standard or preventing financial abuse. They should look at areas where there's a shift from, say, rules-based regulation to outcome focused obligations for firms, and then also look at board level responsibilities, because they'll be the things that influence governance and risk frameworks and internal reporting structures for firms. Also, like the current CPC, so the old/current CPC, only certain sections will apply to certain areas of financial services. So the standards for business regulations, they'll apply across the board to all customers. But then when it comes to the conduct of business regulations, I think always check the scoping section to make sure that a particular provision applies to your business before you act on it. I know that sounds very obvious, but it is worth doing every time. So, for example, for payments and e-money firms, not all of the more general provisions will apply to your business. But look, I completely understand that that particularly for, say, compliance teams, risk managers and boards, the new package can feel overwhelming. And look, I can guess that the audience will already probably guess that as a lawyer, I'm going to say that there's no substitute for reading the regulations themselves and the guidance in order to get your head around where everything sits, and to ultimately understand the framework in its totality, and then where your business sits into it all.
Yeah, that's really interesting, Rowena. And I mean, you've already given some tips on the gap analysis, looking at how it applies to your particular firm. And I suppose once lawyers and the teams in the firms have read all that documentation, they're going to have to implement it and under quite a tight time frame. So Liam, like we're looking at March next year, like what kind of practical steps can firms take in terms of implementing the new CPC?
Yeah, thanks, John. I mean, that's something actually a lot of firms now that we're talking to are, really starting to turn their minds to implementation, because in a sense, the central bank gave quite a bit of advance warning on the likely content of these rules, because in fairness to the central bank, this has been a really well conducted consultation and rulemaking process. I mean, kicked off with the discussion paper in 2022 that outlined a lot of the themes that were of concern to the central bank. Then the consultation paper in March 2024, we had draft regulations at that point in time, and it was a year from the consultation to the actual rulemaking. So and it was a pretty extensive consultation. There were 50, nearly 60 responses, which is a lot by the standards of Irish CBI consultation processes. So I suppose the central bank's thinking would be, well, we've given a lot of advance warning. But again, in fairness to firms have tight resources. There were other things to implement. DORA was a big priority last year for firms to implement on the legal and compliance side. The year before that, they had IAFCR. So what we've seen is that firms are just starting really to get down into the detail of this, in the last maybe 2 months or so. So, the first step, and Rowena touched on it in her comments, the first step is obviously to look at what you've got and to track that across to the new requirements. And the central bank's mapping tool is very helpful in that regard, but it can't be, applied in a sort of tick box manner, because even in places where the central bank's mapping tool shows that a requirement of the existing CPC 2012 is mapped across to a requirement of the new CPC 2025, you may find that there have been wording changes that may or may not, depending on your interpretation, impact on your processes and systems. Now, many of the wording changes are minor, but you still have to, it's a firm's responsibility to comply, and the firm has to decide, is that minor wording change, does that necessitate a change to systems and processes? So that, in my head, is the first stage of implementation, is to do a stock take of what you've got in your existing systems and processes, and how far you think those systems and processes will satisfy the requirements under the new consumer protection regulations, the revised consumer protection regulations. But then there's a whole extra layer that's been brought in the way that CPC 2025 is structured. And Rowena mentioned it earlier, the standards for business regulations. These are brand new. We've never had anything like this before. There were general principles in the existing chapter 2, the existing CPC 2012, but they were very much high-level principles. They were, intended to be borne in mind by firms as a general part of their orientation to customers and the market. They were very rarely cited in direct enforcement by the central bank. They were cited in a small number of cases, mainly the tracker mortgage cases, but by and large, central bank enforcement tended to focus around the detailed provisions of the code and other central bank requirements rather than these general principles. This is going to be totally different. So, again, in my head, the standards for business require a firm to do a broad-ranging end-to-end assessment of its systems and processes, and to benchmark those against the new standards for business, the supporting standards, and the associated guidance that Rowena mentioned earlier. And that's a much more wide-ranging implementation process. It's much more holistic in terms of how the implementation team is going to need to look at the project. And I suppose the other point to mention is that even though that sounds overwhelming, because that's in the space of, well, you've only got 9 months left now. In the space of 9 months, you've got to do a whole holistic evaluation of your entire systems and processes against this set of expectations, brand new expectations. The CBI would say, well, it's not entirely brand new. You're not starting from zero, because you've had the Consumer Protection Risk Assessment Framework, the CPRA, for a number of years now. You should have that well embedded into your systems and processes. And also, they'd say that they have had a focus on culture and conduct within firms and consumer orientation as part of their general supervisory approach for some time. So you're not starting from nowhere, but it is still going to be a big lift. And I think firms need to not underestimate that in terms of timing and resourcing.
Yeah, and you're saying like firms aren't starting from nowhere, and you mentioned DORA, and I suppose firms are still in the middle of DORA, even though it was effective earlier this year. It's an ongoing process. So, we're seeing in the CPC more focus on digitalization. I mean, Dermot, from your perspective, what do you see the challenges for firms in terms of implementing the CPC's new rules on digitalization?
Yeah, I mean, in terms of challenges, I suppose the first issue you always have to do with most tech regulation like this is to work out exactly what you're being asked to do by the legislation. So if you take the first requirement here, which is about making platforms easy to use, understand, and navigate, I mean, some of that is probably common sense, but actually when you sort of think about it in the context of your platform, you need to come up with a specification essentially and sort of specific requirements that you're going to implement. And you need to think about your existing digital assets and split them out from your future digital assets, because future digital assets, they may be relatively straightforward because you can bed in those principles into their design. Whereas when you're talking about existing assets, you're actually talking about change. You're talking about making changes to those systems. The vast majority of the firms at this webinar, I expect, are not tech companies themselves, and they buy in their tech, so they probably license it in from a third-party supplier. So in that instance, then you're talking about actually engaging with that third party and getting them to agree to the changes that need to be made for your legal compliance. So that will sound very familiar to everybody who's been going through DORA for the last year or two, and the idea of reopening your contracts with your ICT providers is probably not that welcome, I wouldn't have thought at this stage. But if there is change needed, you have third-party suppliers, that's what's going to need to happen. Then the sort of linked point is well, what are we actually asking them to do? So how do we practically implement these easy to use, understand, and navigate principles essentially into our platforms? Helpfully, depending, well, yeah, I think it is helpfully. The CBI refers to the Web Accessibility Directive and the principles which are contained in it. So the Web Accessibility Directive is a few years old now. It's focused on public sector websites and apps, and it's about making them accessible for people with disabilities. Interestingly, they refer to that legislation and not the European Accessibility Act, which is actually coming into force this week. I expect that's a timing issue. But the principles that I expect they're referring to are core principles in both pieces of legislation. And that is that your websites and apps need to be perceivable, operable, understandable, and robust. So again, more sort of magic words. But I suppose the helpful point is that in the context of accessibility, we have technical standards which are in place. So under the Web Accessibility Directive, that's EN 301549. Under the EEA, the European Accessibility Act, we don't actually have the technical standards. So I expect that's that timing point I mentioned. So the EN 301 standards are going to be a really helpful guide for people looking at, say, right, well, how do we practically implement these requirements? Because they're the sort of principles that the CBI is referring to. I've got to say, I was a wee bit surprised when I saw that, because so in the accessibility context, and I do a lot of work around the Accessibility Act, the European Accessibility Act, that is focused on people with disabilities, essentially, and making the services usable for them. Whereas for the vast majority of these platforms we're talking about, the users won't have disabilities. So you actually sort of need to be proportionate there, I think, to think about the lift that you're going to make. And like some of the stuff the CBI is talking about in their guidance, they talk about screen readers and voice commands and stuff, which are things I'm very used to seeing in an EEA project context, but not really in a sort of general user applicability thing. So that's quite interesting. I suppose the really helpful point for firms coming out of that is that from a timing perspective, if you've actually gone through your EEA project, so because you're in scope of the EEA, if you're a consumer banking service or you're selling your goods and services online, so you're providing e-commerce services, you're in scope of the EEA, you've done your EEA work, or you'll have your EEA work done shortly, then you're going to be in a really good place for this requirement because you've banked all that work essentially. The second point I'll just mention very quickly is this issue about dark patterns. So sounds quite sinister, but in a tech context, dark patterns just means, well, it's sort of tricks that websites and apps use to make consumers do things or encourage consumers to do things that they don't really want to or need to, like buy something which they wouldn't otherwise have done. So you're impeding the consumer's ability to make an informed choice. So that's a very common issue, which is addressed in the broader tech sort of regulatory landscape. So it started in the Unfair Commercial Practices Directive, it's in the Digital Services Act, it's in the Digital Markets Act, it's in the AI Act. So I'm not surprised to see it popping up now in the CBI's requirements. And the CBI do that in two ways. So they have a specific prohibition in the regulations on pre-ticked boxes where somebody has to tick that they've read and understood something. So that's really common. You can't pre-tick like I agree to the terms and conditions and that type of stuff. That's a really common sort of very clear prohibition. But then they've got a sort of more general sort of prohibitionary type statement in the guidelines where they talk about you can't your platform can't sort of have sort of functionality which seeks to exploit behaviors, habits, preferences, or biases of customers leading to the customer detriment. So that's like a sort of overarching principle that you need to think about in the context of your platforms. Again, the helpful thing is that you're not starting from zero on that. As I say, this issue of dark patterns is very, very common in the tech sector. There's a lot of good know-how, a lot of good guidance out there. If you're speaking to your IT providers, they won't be surprised to hear that type of thing because on this type of language, because that is very, very common. And it's something we deal with a lot. The final point I'll make is just a very small point, but it's just I find it quite interesting that there's a specific requirement now for firms to give a notification in advance of the expiry of the cooling off period. So the period at the start of the contract where the consumer can pull out for no reason. We don't have that in general consumer law, so that's just a sort of special requirement in the FS sector, which you're going to need to be aware of and put into practice.
That's really interesting, Dermot. And I think your themes of accessibility obviously very much come out when you talk about digitalization, and that's linked to another theme in the CPC, which is around the protection of vulnerable customers and preventing financial abuse, Rowena. And this is a focus of the central bank, but actually this is also a focus of clients. Like, clients are very concerned about financial abuse and protecting their customers. We hear that all the time when we meet clients. But in terms of the rules that are now being opposed in the CPC, has the balance been achieved? Are they going to benefit customers, do you think? Or do you think there'll be a lot of bureaucracy around implementing those new rules?
Yeah, thanks. That's a tough one, Joanne. I think, look, you'd hope that the new rules will benefit vulnerable customers, and that the cost benefit analysis around all that weighs in favour of the added protection for those customers. But I think we're going to have to wait and see how it plays out. For regulated firms, I think, it'll be a metric that'll be very, very hard to measure. And let's make no bones about it, like Liam mentioned, firms are going to have to do a lot of work to get their house in order, particularly the smaller firms. We're moving from a position under the current CPC framework that has a one-liner in relation to vulnerable customers that broadly says that a vulnerable consumer should be provided with reasonable arrangements and or assistance that may be necessary to facilitate them in their dealings with the regulated entity they're engaging with. And now we're moving to having standalone regulations dealing with, training for employees on how to deal with vulnerable customers, facilitating engagement with a trusted person on behalf of a vulnerable customer, and regulated firms having to have mechanisms in place to provide for employees to report concerns relating to vulnerable customers. And in addition to that, we also have standalone guidance on how to protect consumers in vulnerable circumstances, which is a good thing, but it's another layer that firms have to factor in. So maybe looking at the first limb of your question, Joanne, as to whether, say, the new expectations will be onerous for firms, I think that how to identify and engage with a vulnerable customer, it is a critical issue, especially given the increasing complexity of financial products and the growing reliance on digital services these days. I think many firms will likely find the new requirements demanding, particularly smaller institutions who might have limited compliance resources. The new code emphasizes early identification of vulnerability, proactive staff training, clearer communication, and more robust internal controls. So that would mean, updating policies, training and retraining staff, and even investing in new systems. The overall intention is that by better identifying and supporting vulnerable customers, that firms can ultimately reduce, say, complaints, their regulatory risk, and the reputational damage that they might face in the long run. I think larger institutions who might already have initiatives in this area and customer-centric strategies already, they're likely to find the alignment with the new CPC's expectations somewhat easier. For smaller firms, I think the transition will definitely take time and effort, and it will feel more onerous for them. Then looking at, say, the second limb of your question as to whether, the rules will benefit customers, is it just going to create bureaucracy? I think, look, there's always a risk that regulation becomes more about box ticking than meaningful change. However, the revised CPC is very much an outcomes-based initiative, having to consider vulnerability more holistically. For example, looking at things like, cognitive, emotional, or financial challenges a person might face, it does have the potential to create real world benefits. For example, if a customer experiencing, say, financial coercion or cognitive decline is identified earlier and given more tailored support, that could prevent serious financial abuse. Many people in the audience will have elderly parents, vulnerable siblings or other relatives who might fall into this overall bracket. And I think that if frontline staff are trained to spot the potential instances of abuse, that can only be a good thing. Like I said, though, of course, implementation matters. So if a firm's approach is to do the bare minimum to achieve kind of top or box ticking compliance, then customers may see little change. But if firms do take the opportunity to, say, embed these protections into their culture and processes, we could see a financial sector that is more inclusive, more responsible, and ultimately more trusted. However, there is a real cost for firms in doing all of this. Systems and processes don't just go ahead and update themselves. And for smaller firms in particular, I think it could feel like there's a wall of regulation standing between them and getting their business done.
Yeah, and that issue of the burden on small firms versus the burden on kind of larger firms who maybe have gone through various projects before is going to just be an issue throughout our conversation. I mean, Liam, maybe briefly, Rowena, this is relevant to vulnerable customers and preventing financial abuse, but the question of informing customers effectively is carried throughout the CPC. And we've seen before where that can lead to actually customers getting a lot of information that maybe isn't necessarily helpful. What's your thoughts on, the central bank's expectations on informing customers and how it might affect product literature?
Yeah, thanks, Joanne. I think, look, it's clear that the central bank expects the whole suite of information that customers receive to change, in the sense that, at the very basic level, the new standard has an emphasis on informing customers effectively, and it specifically uses the terminology ensuring that the customer is informed effectively, whereas the previous standard in CPC 2012 just talks about firms seeking to use their best efforts to inform, or some language like that. So there's much more of an emphasis in the CPC 2025 on the firm's responsibility being to make sure that the customer is effectively informed. Now, what does effectively informed mean? For that, there's a new standard for business on informing effectively. There are supporting standards. There's guidance on informing effectively. The guidance identifies 7 core issues that firms need to have in mind in terms of assessing their provision of information to customers, to determine whether or not that information is sufficient to constitute effective information. I'm not going to go through each of the 7 core issues, mindful of time, but the kinds of things that firms are now expected to have at the center of the development of any form of information or material provided to customers are things like plain language, careful layout, how information is displayed, the kind of delivery channels that they adopt. And the central bank speaks in very approving language of delivery channels like videos and infographics, on the basis that this is much more, can be much more effective as a means of informing customers than the traditional provision of reams of paper. One of the points that I found quite interesting, and in many ways the examples that the central bank gives in the informing customers effectively guidance, are in many ways more instructive than the text of the guidance itself, because the examples really help to give concrete illustrations of what the central bank thinks are good practices versus bad practices, or versus, not bad, but less than optimal practices. And one of the points that I took out of one of those examples is around prescribed regulatory disclosures. And it's been a criticism of a lot of the European regimes for mandatory provision of regulatory information for a long time, that makes it actually more difficult to inform customers effectively because of the prescribed content of a lot of those disclosures. The central bank says, yeah, look, we know that you're required, say for the specific example they give is PRIPS. They say, look, we know that in the case of a PRIP, there's a whole load of prescribed regulatory disclosure, but that doesn't absolve you. Just because the content is prescribed, that doesn't absolve you from still considering and assessing that disclosure in the light of informing customers effectively. You can still adapt. You can format it in a different way. You can use colors, you can text boxes, you can simplify the language. So you can still comply with your obligation to give prescribed regulatory disclosures, and do your best within that framework to inform customers effectively. So I thought that was really interesting, because it sort of takes away the argument, hey, this is all prescribed regulatory material, so we just don't touch it. That's quite a high bar to put on firms in terms of informing effectively.
Yeah, and I think PRIPS actually is the area I'm thinking of that has historically been identified as where increased information was required, and there's a query as to how much benefit it led to consumers or customers. And Liam, I might keep you then just to ask you about, there's a new standard around securing customers' interests, and there's been a lot of discussion around this new standard. It's within the business standards, and I suppose parallels may be drawn with the UK consumer duty. Do you want to provide us with a bit more detail on that? And then we might ask Ben to talk to us a bit about the UK consumer duty and his experience there.
Happy to do that. I think before I do that, Ben, you had something you wanted to, you and I had a chat before this about the provision of information to customers. You made an interesting point on that.
Yeah, sorry to cut across your segue, Joanne, but I think just one other point to add to what Liam was saying, because I think that's all kind of makes sense against the experience in the UK, where maybe we've kind of had the consumer duty for a bit longer and it's had the same focus. One point the SCA's pulled out when looking at kind of consumer understanding and communications has been they were quite keen and complimentary when reviewing it of firms that were testing customers' understandings in qualitative ways. So there was a lot of evidence of firms kind of on the good side of practice, undertaking surveys, doing experiments with customers, and kind of conducting interviews afterwards to actually get into the weeds and identify whether the way they were communicating and the means by which they were communicating was effective and how they could change that. So I think, as well as kind of doing the work over the next period of time up till March for Irish firms to understand how to kind of change your communications to meet the requirements, I expect that the CBI takes the same approach as the SCA. They'll also want you to be gathering the information and testing it on an ongoing basis to demonstrate really how you can improve those communications over time in practice. That was the only point I just wanted to add at the side.
That's really useful, actually, Ben, because I know that there are a number of the larger Irish firms that are already doing that in terms of customer disclosures. They're doing that market testing and having, but I'm, you know, to the extent that it's not a general market practice yet, I think you're absolutely right that it's one that you know is likely to become much more common in the market. So on securing customers' interests, I'll just speak briefly on the Irish standard, because in my mind, this is one of the, I suppose, most significant changes to the consumer protection regime as a result of the introduction of CPC 2025. So this is a standard for business. Rowena mentioned earlier the distinction between the standards for business regulations and the consumer protection regulations. So it's a high-level standard which applies to all regulated firms. Now, it only applies to them insofar as their business is dealing with consumers. And consumers, as all of you will know from the CPC 2012, includes not just individuals and partnerships and natural persons that are trustees and unincorporated associations like clubs and so on and so forth, but it also includes companies with a turnover of, under CPC 2012, up to 3 million, and under CPC 2025, that's going to go up to 5 million. So it includes small businesses effectively. This SCI standard for securing customers' interests, excuse me, builds on the previous general principles 1 and 2 of the CPC 2012, which required firms to act in their customers' best interests. But as I mentioned earlier, those principles were relatively little developed by CBI guidance and elaboration. A lot of firms were unclear as to what those those general principles required of them, and they were fairly rarely used as the basis for central bank enforcement. And this whole question of acting in customers' best interests, securing good outcomes, et cetera, was one of the main areas that the central bank identified very early on in its discussion paper of 2022 as an area for regulatory action. So it was clear that there was going to be a focus on this from the very get-go of the reform project. And they cited examples of firms that hadn't acted in the best interests of customers through the tracker mortgage cases, through payment protection insurance, through COVID-19 business interruption insurance, and so on. So the SCI standard has, within the regulations, and the regulations, by the way, the standards for business regulations are well worth a read because they are actually quite readable. It's a relatively short piece of legislation. And each of those standards for business has 9 supporting standards. So the supporting standards are, if you like, concrete illustrations of what is required under the main standard. So among the 9 supporting standards are aligning your business model with securing customers' interests, meeting customers' expectations, safeguarding customers' interests when designing products and services, not exploiting customer behaviors and biases unfairly, resolving errors and mistakes efficiently, disclosing those to other affected customers, and applying similar resolution across the affected cohort. And very importantly, it's sort of the last of the supporting standards, delivering fair outcomes. And let's focus on those words, fair outcomes for customers. Again, just to repeat myself, but I think it bears repetition, the standard for business and the supporting standards are drafted using the word customers, but they only apply to consumer-facing business. So don't get confused by that. The standard and the supporting standards already, from a lawyer's reading, go well beyond the existing general principles because they talk about an obligation to deliver fair outcomes to your consumers. And straight away, I ask myself as a lawyer, what is a fair outcome? What does that look like? And the central bank has tried to give guidance on what a fair outcome looks like in the securing customers' interests guidance. And there are some key themes in that guidance. I mean, first of all, they say the guidance is consistent with other areas and has to be read consistently with other areas of central bank rulemaking, such as the CPRA. Proportionality applies, but at the same time, all firms have to respect the obligation. Customer autonomy is important, but customer autonomy is not an absolute defense because the customer has to have been effectively informed to be able to exercise his or her autonomy. Firms' culture and systems have to be aligned with securing customers' interests, and this is not a box-ticking exercise. It requires a root and branch assessment of a firm's culture and systems and of its strategic decision-making processes in order to ensure that securing customers' interests is placed at the heart of all of those processes. Firms have got to be very careful if they're targeting customer behaviors or biases or preferences, that they don't do so in any kind of manner that could be considered to be unfair in the light of the securing customers' interests standard. And then it's, again, a very interesting use of language. Firms should strive for positive outcomes. So at the beginning of the guidance says, look, it's not, we don't expect that a consumer will get a positive outcome in every case. But then at the end of the guidance, it says firms should strive for positive outcomes at all times. So there's this tension between recognizing that customers have autonomy, markets can turn in ways that customers don't like, products have inherent risks which customers are entitled to accept, and so customers will not always come positively out of a product. But at the same time, there is an enhanced obligation imposed on firms to ensure that customer autonomy is exercised in a manner where those customers are fully informed, that they fully understand, and that the firm has to strive at all times to give those customers a positive outcome as far as they can. I'm going to stop there because I think what's going to be really interesting now and instructive is to hear Ben in terms of how this parallels to the UK's consumer duty, which has been enforced now for a number of years, and UK firms have had experience of implementing this.
Yeah, thank you very much, Liam, and thanks for the team for inviting me to join this kind of really important webinar. So as Liam was saying, in the UK, we're maybe 2 or 3 years into the future here. We've had the consumer duty for at least new products since 2023, and I suppose we were where you are now in 2022 on the kind of short run into implementation and trying to scramble things together. So I suppose my role in the next 5 to 7 minutes is maybe try and give a perspective of where we are a bit further down the duty and give maybe a glimpse into the future. So, I mean, I think kind of one important thing to highlight is while there are some important differences between the scope and detail of the CPC 2025 and the consumer duty, I think there's kind of some real key similarities, particularly in the shift of emphasis by the CBI and the FCA. So it is a demonstration of a move away from what I suppose we would describe as rules-based regulation towards outcomes-based regulation. So it places the emphasis now on firms, as Liam was just talking about, to deliver a certain type of outcome for the customer, not just to comply with the rules and then whatever happens after that. And I think another kind of key feature to pull out of that, at least that's been our experience in the UK, and I think will be your experience in Ireland, is these are really fundamental changes, and I think both regulators intend for the new regimes to set the foundation for how they regulate retail firms going forward. And I think there's kind of has to be an acknowledgement these are big structural change undertakings for firms. There's an expectation that you shift how you do business generally, and also your culture catches up with that. So, I mean, just to give a little bit of background on the UK consumer duty for those who maybe haven't seen it before. When it was implemented in 2023 for new products and then in 2024 for legacy products, it was a result of a really long period of consultation by the FCA from sort of 2018, 2019 in relation to a new proposed consumer duty, and that resulted in a few different changes in emphasis. But really what was driving that for the FCA was a recognition, I think similar to the CBI, that the current rules and principles weren't delivering great outcomes for customers. And also, and I think it's probably important to pull this out in the Irish context, the FCA had a frustration that when things had went wrong in the past, if they couldn't identify a specific rules breach, the current kind of principles, particularly treating customers fairly, was a bit too subjective and really hamstrung them in taking effective enforcement action. So for the FCA, at least, the consumer duty has two sides. It's intending to kind of lift the floor for firms and challenge them to deliver good outcomes, but also in the background, I think it's worth being aware that the regulators are looking for tools to kind of enforce that compliance at a further stage. So the form in which the consumer duty took in the UK was effectively similar to what Liam was talking about in the requirement to deliver outcomes for customers in Ireland. We have a consumer principle which requires firms to deliver good outcomes for retail customers. And then that's supported by a number of different requirements. So firstly, we've got 3 cross-cutting rules requiring firms to act in good faith, to avoid causing foreseeable harm, and support customers in pursuing their financial objectives. And those cross-cutting rules are really intended to give firms in the UK guidance on how to implement the consumer principle and what the FCA's expectations are in relation to that. And then finally, we have kind of as part of the requirements for grouped outcomes in relation to ensuring that products and services are fit for purpose and meet the target market's needs, that products represent fair value, that communications are clear and support informed decisions, and that there's actual helpful, accessible customer support. And that's supported by quite detailed guidance from the FCA around what they specifically expect from firms to actually achieve for customers in those circumstances. I think quite similar to the supporting requirements for the CPC 2025. And then finally, again, similar to the CPC 25, there's quite detailed requirements in the UK around the FCA's expectations for firms' governance in relation to the consumer duty and also the information they obtain, because at least in the UK, I think one of the key themes that's come out since the consumer duty has been in place is the FCA doesn't just expect you to do this work and then it to be a one-off and it's done after March 2026 for you. At least our experience in the UK is actually it has permeated the FCA's entire approach to regulating retail firms. So they are interested in the annual report that firms prepare on consumer duty, and in particular the areas for improvement they've identified and their strategies for addressing them. They also want firms to have MI in place and to get appropriate MI across their distribution chains, because the challenge isn't just to say to the FCA, or I suppose the CBI in this case, that we've done the work to meet the consumer duty. Is actually, in certain circumstances, if you're asked to be able to prove it through effective MI that you use to monitor your improvements on an ongoing basis. So, I mean, I think maybe looking forward to what we're seeing in the UK market and how the FCA is implemented in practice, maybe kind of, and possibly a glimpse into the future for the CBI. As I was saying, since the consumer duties come in, I think it's really important to emphasize that this has, for the FCA, the consumer duty has become the core and the foundation of how it regulates UK retail firms. So we're seeing for firms, it's a core part of any new application for authorization. There are questions about changing control forms and other regulatory applications around how firms intend to comply with the consumer duty going forward. As I mentioned, those annual consumer duty reports are really closely reviewed by the regulator, and actually consumer duty compliance, consumer duty issues, and plans to address it in the long run make up a very key part of discussions with regulators on an ongoing basis. I think as well across the UK market, we've seen the consumer duty really driving and setting the core for a number of market initiatives. And I think that will continue. So, for example, we've had a gap insurance market review, which really stemmed from a challenge by the FCA to firms to demonstrate that that product was appropriate for customers and delivered good value. Similarly, saving products for a number of banks have been challenged by the FCA in relation to whether they deliver fair value, and they've requested assessments of that and what work the firms have done on an ongoing basis. And then aside from kind of public announced action, we're also aware from our work with clients in the UK that anytime an issue is raised or there's an area of concern, it's really being framed through the lens of the consumer duty, and that's shown through Dear CEO letters, but also private discussions with regulators. So I think probably the important point I'd like to kind of comment to take away from is I suspect the experience of Irish firms, the CBI going forward after the implementation of the CPC 2025 is going to be quite similar to that in the UK, in that it's going to set a new paradigm for how the CBI regulates retail firms. While the requirements have similarities to what there is previously, I think it could become more central to how you regulate and what you're asked to establish. And I think also a key point to emphasize is, at least in the UK, it wasn't a project you did and then you finished in July 2023 or 24 in the UK, or I suppose in March 2026 for Ireland. It's something where the FCA expected you to continue to do it and to continue building on that work as a longer cultural piece of change that isn't just a one and done, I suppose. So yeah, Joanne, I think we might be moving on to the Q&A section next?
Yeah, I mean, that was so helpful, Ben, and so insightful. Can I just ask you, I mean, you're talking about it not being a one and done exercise, and you've run the gauntlet on this. I mean, what kind of, do you have any lessons learned or kind of tidbits we can give the audience in terms of what you've seen has worked or hasn't worked in terms of implementation over the last few years?
Well, I think maybe I'll cheat a little bit on that, Joanne, in the first place. So one of the helpful things, if you're looking for ideas, the FCA has done, and like the CBI, I think, to be fair, as regulators, they have tried their best with this. I think they recognize it's a change, is across a number of sectors, including insurance, the FCA has actually looked back in the last few years and said, okay, against our outcomes, what's went well and what hasn't went well, and what is good practice and bad practice. And actually, there's an FCA paper that if anybody's interested in digging in, that probably does that work in quite a qualitative way. But I think given where we are in the cycle within Ireland at the moment, one of the things probably to emphasize, and it comes from what we were talking about in the roundtable earlier on, is March 2026 isn't very far off. 9 months is a very short period of time to get through a lot of this work. And I think the experience in the UK, particularly from the SCA, is the SCA got quite head up about the fact that firms seemed to be leaving it to the last minute. So even if they were working quite hard, it was a hard deadline and they were expected to comply with it. So I suppose the one lesson learned to kind of encourage is you really need to, if you haven't started now or kind of be running now, to be doing that to get your senior management engagement and to kind of press forward with it, because it is just a lot of work, and it's a change project. It's a cultural change. It's a change in products, in how you govern your products. Like as Dermot was talking about, even just reviewing your terms to make sure they work for customers. That's a really big undertaking. So yeah, just don't underestimate it, I think, is the one key piece of advice.
Thanks so much, Ben. And like you said, we have lots of questions, which is brilliant. Thank you so much, everyone. Maybe before we turn to the questions, I think we probably have some poll results. We can see how everyone answered. So is your firm prepared for implementing the new CPC? Yes, 70%. Well done, everyone.
Well done.
No, 30%. So that's great. And maybe reflective of what we said, and that, some firms will have already done the legwork on this. Which aspect of the new code do you anticipate being the most challenging? Managing digitalization and securing customers' interests, which I think would align with our thoughts. And do you believe the new code will significantly improve outcomes for customers? And 72% say yes, which I think is really fantastic, because that's really the goal here, isn't it? And does anyone want to comment on the poll before we move to the Q&A?
Before we go to the poll, Joanne, I just had a couple of questions, questions/comments just on the UK experience that I thought would be interesting just to put to Ben. Ben, I know one of the areas of the UK consumer duty that caused most difficulty was the fair value requirements, and I think if I'm right, that required a number of firms, particularly for legacy products, kind of closed products. Some firms actually had to exit those products. They had to sort of withdraw them, and then you get into all sorts of complexity about whether you could withdraw. Now, we don't have explicitly that fair value, requirement to deliver good value or fair value. I suppose, do you see that? I mean, would you, if you took that fair value requirement out, if that hadn't existed in the UK, do you think that the lift in the UK would have been easier? I suppose what I'm angling at is, are Irish firms potentially in a better position than their UK counterparts were because we don't have that explicit requirement?
I mean, I think it's a good question, Liam. I think in the UK we've been on a bit of an odd journey with value. So maybe 10 years ago, the SCA would have been really clear that it wasn't really interested in monitoring value prescriptively, but actually we've now got requirements that, for example, in insurance in relation to kind of price walking, where we've seen the SCA enter that. Enter value is kind of a clear driver. I think it would have been a much easier lift. I think it's come through in some of the questions we got through, but legacy products have been particularly hard. And I was a bit surprised, to be honest, when I was looking at the CPC, how the CBIs approached it, that legacy products weren't pulled out, because looking back at a 10-year-old kind of investment product and wonder in the UK, for example, like firms had to do, and wondering, does this actually deliver value for customers? Is the charging structure appropriate? And even when you recognize the harm there, actually even figuring out how you mend it in practice, like, can you do a unilateral amendment, or do you have to approach all your customers who might have gone away to individually address it? Like, I think it's been a very big challenge. I imagine the CBI still wants your products to deliver fair value, even if it's not explicitly saying it. But I think not having a measure against it, probably it might make your life slightly easier in Ireland, I suppose. I think there might be some people on this side of the Irish Sea who are a bit jealous.
Okay, thanks. That's great. Joanne, you were going to ask us about some questions.
Let's pull some questions. One question: how can you ensure that information is drafted and presented for understanding by an average customer? Who would like to take that? Rowena, I see you unmuting yourself. Thank you.
I'll jump in on that one. Look, I think the expectation around that is always that things are drafted in very plain English, that they're consumer friendly. I think there are references in the Conduct of Business Standards to testing. So not particularly in this area, but testing around certain language used for, say, your variable rate interest policy. The central bank refers to testing by consumers of the language. So that might be something that's worth doing across the board, is to, you know, have a small subset of people come in, read the language and kind of confirm or otherwise that the language is actually readily understandable by them. And at least to the extent, you know, the central bank was ever questioning your practices, you could say, well, actually, we didn't have to do this testing, but we did it anyway. And we were confident that your average customer could understand what we were putting on our website or in documentation that we were providing to consumers.
Thanks, Rowena. And next question, how do we reconcile this, I think the CPC, with the Assisted Decision-Making Capacity Act and the customer's right to do the wrong thing? Anyone? Liam, would you like to
I'll say
that?
a few words about that. I'm not an expert by any manner of means in the Assisted Decision-Making Capacity Act, but the central bank has called it out explicitly in CPC 2025. They're clearly well aware of it. They know that it's part of the sort of foundation of foundation stone, if you like, of what they're doing. I think their view would be, yes, customers, customers do have the right to do the wrong thing, but in financial matters, firms have to do their utmost to safeguard customers against doing the wrong thing. You know, they're not saying, you know, under no circumstances can a vulnerable customer be allowed to make a financial decision that would be to their detriment. They haven't said that. That's not what the CPC 2025 requires. But you know, what they are saying is firms need to have processes in place to identify vulnerable customers. They need to have safeguards. They need to make, you know, go above and beyond to make sure that those people, you know, that they have the training in place, etc. So I think they can be reconciled. I think what is probably likely, and I'm trying to read the central bank's mind here, but I suspect that the threshold for a firm's behavior is going to be higher in financial services versus other areas of services before the central bank will be happy to say, yes, okay, we accept this vulnerable customer had the right to do the wrong thing. And we're also happy that you discharged your responsibilities to it. I think that bar is going to be higher in FS than it's going to be in other sectors. That'd be my way of reconciling it.
Yeah, and I suppose maybe I'll just grab one final question. I suppose the question everyone always asks in terms of regulatory changes, what are the possibilities of enforcement? You know, what approach do we think the central bank might take? I'm happy for everyone to gaze into their mirrors, crystal balls here. And maybe Ben, you could give us some insight into the FCA as well. Rowena, do you want to chat about what you think the central bank might do? And Ben then might give us a flavour of FCA approach.
Yeah, I think from, say, a central bank perspective, I think, okay, parking an egregious breach. I think the central bank will allow firms some leeway to embed the new CPC practices and procedures into their frameworks. And given that, you know, this comes into effect next year, I think what we might see is the central bank including it as a supervisory priority or focus for 2027 or 2028, with themed inspections maybe flowing out of that, and then ultimately some enforcement action. So I think we are actually a bit away from enforcement, but I think that time will actually go by very quickly. So I wouldn't let that delay implementation projects by any means. And I think when, you know, firms are preparing their revised frameworks, I think it's always worth keeping an eye on what enforcement could look like in the back of your head. So, you know, if things were to go wrong, how do we design our framework to best avoid that? But I think hopefully we're a little bit away from enforcement, as I said, unless something kind of really egregious happens that the central bank comes across.
I mean, I think, Rowena, that's probably the experience in the UK so far. To kind of 2 or 3 years down the line, we haven't had kind of a lot of public enforcement in relation to the consumer duty. We've had kind of market schemes looking at things and challenging firms on how to address points, and where issues have been identified. I think we're aware of private redress schemes being kind of ordered or suggested quite firmly by the regulator. So I think the point to say is it's probably a bit further down the line, but at least the experience in the FCA has been, certainly the tenor from the regulators being, we're intending to use this as an enforcement tool when things go wrong as well. And now it's an outcomes-based measure rather than a kind of firm, you complied with the rules, so you're fine. there will be an element of hindsight. So I imagine kind of when an enforcement action comes through, it's quite hard to wriggle off if you don't think you've delivered a good outcome or a reasonable outcome for customers as well.
Great, thanks so much, guys. I'm going to have to wrap it up, even though I think we could do 3 more of these. Can I thank my panelists? Thank you so much for all your insights today. And in particular, thank you, Ben, for joining us from London. We really appreciated hearing about the UK. For the audience, thanks a million for attending. You'll receive a feedback survey on your screen. You have to complete that feedback survey to receive your all-important CPD certificate. So everyone make sure to do that. So thank you very much to all our panelists, and thanks to our audience for attending today. We'll speak to you soon on our next webinar.